U.S. Marshals are on the move right now. Judge Eleanor Caldwell has just issued arrest warrants for multiple individuals following the explosive leak of what's being called the Witness 14 tape. For the first time in this entire case, a federal judge has authorized immediate custody orders based on recorded testimony that was never supposed to see the light of day. Sources inside the courthouse describe scenes of chaos, attorneys scrambling, phones confiscated, and marshals positioned at every exit. This isn't a procedural motion. This isn't another delay tactic. This is a sitting federal judge declaring that what she heard on that tape constitutes prima facie evidence of serious federal crimes and demanding bodies in custody before sundown. So what triggered this unprecedented judicial action? 47 minutes of recorded testimony from a protected witness designated only as Witness 14 leaked online late Thursday night. Within hours, it had been downloaded over 2 million times before platforms scrambled to remove it. This isn't just another scandal in a case already drowning in scandals. This tape reportedly contains what legal analysts are calling the smoking gun, direct recorded evidence of coordinated criminal activity that names names, cites dates, and describes specific illegal transactions in granular detail. And I have the breakdown of exactly what that tape reveals right here. Let me show you what they desperately tried to keep buried. What makes this different from every other leak in modern legal history is Judge Caldwell's response. She didn't order an investigation. She didn't schedule a hearing. She issued arrest warrants within 6 hours of verifying the tape's authenticity, a move that former federal prosecutors are calling virtually unprecedented in modern American jurisprudence. The individuals named on those warrants reportedly include figures nobody expected to see in handcuffs. The marshals deployed aren't local, they're federal, and their orders come directly from a judge who has clearly seen enough. Here's what the Witness 14 tape actually reveals. According to verified transcripts now circulating among legal experts and journalists, the recording captures a protected witness describing a systematic operation to obstruct justice, tamper with evidence, and intimidate other witnesses in the case. This is it. This is what everyone's talking about. The witness, whose identity remains sealed by court order, reportedly details how they were personally directed to destroy documents, alter digital records, and coordinate false testimony with at least 4 other individuals. The tape includes specific dates, March 14th, April 2nd, and May 19th of this year. It names 3 previously unidentified co-conspirators and describes cash payments totaling over $340,000 distributed specifically to silence potential witnesses. According to legal analysts who reviewed authenticated portions, the level of specificity is staggering. The witness reportedly states, quote, "I was told exactly what to say. They gave me a script. When I asked what would happen if I didn't follow it, they made it very clear my family would face consequences." This wasn't witness preparation. This was witness tampering at a level that prosecutors say constitutes racketeering. But here's the kicker. The tape also captures Witness 14 describing a meeting where alleged destruction of evidence was discussed in explicit detail. The recording reportedly includes the witness recounting how documents were shredded, hard drives were degaussed, and cloud backups were systematically deleted, all while the investigation was active and subpoenas had already been issued. Former federal prosecutor Marcus Webb told the Daily Beast that this recording represents the clearest documented evidence of obstruction he's seen in 30 years of practice. The specificity is what makes this devastating. The witness doesn't speak in generalities. They provide badge numbers of individuals allegedly involved, physical descriptions of locations where illegal meetings occurred, direct quotes from conversations they participated in, banking information related to alleged payoffs, and names of attorneys who allegedly facilitated the scheme. And it gets worse. The tape's final segment reportedly contains Witness 14 describing threats made against their own children. The witness states that photographs of their kids' school were sent to their personal phone, accompanied by a message reading, "Testimony has consequences." Professor Danielle Reeves at Georgetown Law emphasized that this elevates the charges dramatically. Threatening a witness is obstruction. Threatening their children is witness intimidation at its most severe, a separate federal felony that typically carries enhanced sentencing. The tape runs 47 minutes total. Legal experts note that approximately 31 minutes contain directly incriminating testimony, with the remainder covering procedural questions from the interviewing attorney. The recording quality is reportedly exceptional, clear audio with no gaps or apparent editing. Multiple authentication experts have now confirmed the tape appears genuine. Vocal analysis matches previous verified recordings of the witness. Metadata indicates the recording was made on the date claimed, and references within the tape to external events have been corroborated by independent documentation. Sources close to the investigation confirm that Judge Caldwell personally reviewed the full tape before issuing her orders. According to courthouse sources, she watched it twice, stopping only to consult with her clerks on applicable statutes. The transcript excerpts that have leaked are damning enough, but those who have heard the audio describe something even more powerful: the witness's voice, the fear, the exhaustion, the resignation of someone who knows they're risking everything. One journalist who obtained the tape described it as 47 minutes that will redefine this entire case and possibly this entire era of American justice. Hit that subscribe button right now because this story is exploding in real time. Arrests are happening as we speak, and you won't want to miss a single update. Subscribe immediately if you want the real story before mainstream media catches up. Now, you've heard what's on that tape, but here's how we got here, and it makes this revelation even more devastating. This case has been building for over 2 years. What started as a routine financial investigation gradually expanded into what prosecutors now describe as a sprawling criminal enterprise involving fraud, corruption, and systematic obstruction across multiple jurisdictions. Tensions had been escalating for months, fueled by repeated delays, sealed motions, and the mysterious withdrawal of 3 previous witnesses who suddenly claimed memory problems under oath. Legal observers had grown increasingly frustrated with what appeared to be a case slowly dying from procedural strangulation. Everything changed on October 3rd when witness 14 first entered protective custody. According to court documents, witness 14 was an insider, someone with direct knowledge of operations, who initially cooperated with the defense before dramatically switching sides. Prosecutors moved them into witness protection within 48 hours of their decision to cooperate, citing credible threats. For months, witness 14's testimony remained sealed. Defense attorneys filed 17 separate motions attempting to access the recordings. 17 times Judge Caldwell denied them, citing ongoing security concerns and the witness's protected status. This wasn't about protecting legal strategy. This was about protecting a human life. On November 8th, the defense filed an emergency motion claiming prosecutorial misconduct, alleging that witness 14's testimony had been coerced. Judge Caldwell scheduled an evidentiary hearing for December 2nd. That hearing never happened. On November 29th, the tape leaked. Anonymous accounts on encrypted platforms began distributing fragments. Within hours, the full 47 minutes appeared on multiple hosting sites. By midnight, it had spread beyond any possibility of containment. Judge Caldwell convened an emergency session at 6 a.m. the following morning. Courthouse sources described her as visibly furious, not at the content of the tape, but at its unauthorized release. The leak itself constitutes a federal crime, she reportedly told assembled attorneys. But the contents of this recording constitute crimes of far greater magnitude. By noon, she had issued the arrest warrants. What makes this case unique isn't just the crimes alleged, it's the documentation. Typically, obstruction cases rely on circumstantial evidence, conflicting testimony, and complex forensic reconstruction. This tape provides something prosecutors almost never get: A direct witness describing criminal conduct in real time with specificity that leaves virtually no room for alternative interpretation. Smash that like button if this is connecting the dots for you. This case is complicated, but the evidence is crystal clear. Drop a like if you're following along. Every like helps this reach more people who deserve to know the truth. The bombshell moment came at 11:47 a.m. when Judge Caldwell took the bench for her emergency session. Attorneys for both sides had been summoned with less than 4 hours' notice. Some arrived still pulling on suit jackets. Others hadn't slept. The gallery, normally restricted, had been sealed entirely. No press, no public, only essential personnel. Courthouse reporters positioned outside described an eerie silence. Then marshals began taking positions at every entrance. Deputies who normally patrol the parking structure were reassigned to interior corridors. When Judge Caldwell finally spoke, witnesses say her voice carried a weight they'd never heard before. "I have served on the federal bench for 22 years, she reportedly began. I have never encountered evidence of witness intimidation, this explicit, this organized, or this contemptuous of this court's authority." The courtroom went silent. Defense attorneys reportedly exchanged glances. Then she read the names one by one, 4 individuals, arrest warrants signed and sealed. When she finished, she looked directly at the defense table. If any officer of this court had knowledge of these activities and failed to report them, they should consider their own legal exposure very carefully in the coming days. 2 attorneys immediately requested to withdraw from the case. Judge Caldwell denied both motions, citing the ongoing investigation. That's when it became clear this isn't just another case falling apart. This is a federal judge declaring war on obstruction itself, with the full weight of the U.S. Marshals Service backing her authority. Stay with me. What comes next changes everything about how we understand this case. Drop a comment below. Did you see this coming? Were you following this before the tape leaked? I read every single comment and want to know your thoughts. This isn't the first time a leaked tape has demolished a legal defense, but the speed of judicial response sets this apart from every modern precedent. Think back to Watergate. When the Nixon tapes finally emerged, they revealed a president directly coordinating obstruction from the Oval Office. But that revelation took years of legal battles, congressional investigations, and a Supreme Court ruling forcing their release. The system moved slowly, methodically, carefully. When the Access Hollywood tape leaked in October 2016, it exposed conduct that would have ended most political careers. But there was no judicial response because there was no active case. The tape existed in a legal vacuum. The key difference now is that Judge Caldwell isn't waiting. The Martha Stewart case offers perhaps the closest parallel. Stewart wasn't ultimately convicted for insider trading. She was convicted for obstruction and lying to investigators. The cover-up proved worse than the original crime, but even that case took months of deliberation before charges were filed. Here, Judge Caldwell moved from tape verification to arrest warrants in 6 hours. Legal historians are already comparing this to the Saturday Night Massacre of 1973, when Nixon's attempts to obstruct the Watergate investigation led to dramatic resignations and ultimately his own downfall. The parallels aren't perfect, but the underlying principle is identical. Obstruction itself becomes the central crime, overshadowing whatever was being hidden. The pattern is clear. When recordings emerge that document criminal conduct in real time, the cover-up consistently generates more legal jeopardy than the original offense. Now, however, we're seeing something new. A federal judge treating obstruction not as a secondary charge to be added later, but as an emergency requiring immediate law enforcement response. Judge Caldwell has essentially declared that the integrity of the judicial system itself cannot wait for normal procedural timelines. That's unprecedented, and it may reshape how federal courts handle evidence tampering and witness intimidation for decades to come. Legal experts are calling this a watershed moment for judicial authority. Former U.S. Attorney Preet Bharara, now at NYU Law, told MSNBC that Judge Caldwell's actions represent exactly what courts are supposed to do when confronted with clear evidence of obstruction. Act decisively to protect the integrity of proceedings. He emphasized that the speed wasn't reckless, it was necessary. When you have witnesses being threatened, evidence being destroyed, and testimony being coordinated, every hour of delay allows more damage. Judge Caldwell understood that waiting means losing. Meanwhile, constitutional law professor Lawrence Tribe noted that the judicial authority to issue arrest warrants based on leaked evidence raises complex questions, but ultimately supports Caldwell's decision. The source of evidence doesn't determine its admissibility or its weight. Tribe explained that the leak was illegal, but the conduct documented on the tape was also illegal. The judge has an obligation to respond to both, but the greater crime clearly takes priority. A former federal public defender who requested anonymity to discuss the case freely offered a more cautionary perspective. Defense attorneys are going to argue that this tape was illegally obtained and should be inadmissible. That's a legitimate legal question, but the arrest warrants aren't based solely on the tape. They're based on the judge's finding that ongoing criminal conduct requires immediate intervention. Criminal justice expert Rachel Barkow at NYU Law School added that the targeting of witnesses' families represents an especially serious escalation. Threatening children crosses every line. It transforms witness tampering into something closer to domestic terrorism. Federal sentencing guidelines treat this as an aggravating factor that can add years to any eventual sentence. Even former prosecutors, who typically advocate for deliberate, methodical proceedings, have supported Caldwell's response. In normal circumstances, you'd want to take more time, admitted former DOJ official Harry Litman. But these aren't normal circumstances. You have a protected witness whose family was threatened. You have evidence being actively destroyed. The judge faced a choice: act now or watch the case collapse. He noted that Judge Caldwell's reputation for meticulous, by-the-book jurisprudence makes her response even more significant. This isn't a judge known for dramatic gestures. Eleanor Caldwell has spent 22 years building a reputation for patience and precision. When she moves this fast, it tells you exactly how serious this is. The consensus among legal observers is striking. Regardless of political perspective, the evidence on that tape demands an immediate response, and Judge Caldwell delivered it. If this analysis is valuable to you, smash that like button. It genuinely helps more people see this coverage when the algorithm recognizes engagement. One click from you means this story reaches someone who needs to hear it. So what does this actually mean going forward? First, the immediate legal exposure for those named in the warrants is staggering. Federal obstruction charges carry statutory maximums of 20 years per count. Witness tampering adds another 20 years. Threatening a witness's family members creates additional charges under federal intimidation statutes. And if prosecutors can establish coordination among multiple defendants, RICO provisions could multiply sentencing exposure exponentially. This puts everyone named on those warrants in an impossible position. On one side, fighting the charges means discovery, meaning prosecutors get access to communications, financial records, and testimony from additional witnesses. On the other, cooperation means implicating others, potentially including individuals with significant power and resources. Neither path offers safety. Second, the professional consequences extend far beyond prison time. At least 2 attorneys have already sought to withdraw from the case, and legal ethics experts suggest more will follow. Any lawyer who knew about the obstruction scheme faces potential disbarment and criminal liability. The tape apparently references legal counsel facilitating witness coordination. If those references prove accurate, the defendants may find themselves unable to retain experienced representation. Bar associations in 3 states have already announced preliminary ethics investigations. The American Bar Association's Standing Committee on Professional Discipline is reportedly monitoring the case closely. Third, the long-term implications for judicial procedure could reshape how courts nationwide handle obstruction allegations. Judge Caldwell has established a precedent. When evidence of ongoing obstruction emerges, courts can and perhaps must respond immediately rather than allowing procedural delays that enable further criminal conduct. This matters because obstruction cases typically move slowly. The standard approach involves methodical investigation, grand jury proceedings, and careful charge construction. What Caldwell has done is essentially declare that some circumstances don't permit that deliberation. When witnesses are being threatened and evidence is being destroyed in real time, the court has both the authority and the obligation to intervene immediately. The implications for the rule of law itself are profound. For years, critics have argued that powerful defendants can obstruct justice with impunity, using delay tactics, witness intimidation, and evidence destruction to prevent accountability. The standard judicial response has been patience, process, and deference to procedural norms. Judge Caldwell's actions represent a different model. Aggressive, immediate judicial intervention when obstruction threatens to defeat justice entirely. If other federal judges follow her lead, we could see a fundamental shift in how the American legal system handles defendants who attempt to corrupt proceedings. The message would be clear: obstruct at your own peril, because courts will no longer wait politely while you destroy the case against you. The coming weeks will determine whether Caldwell's approach becomes a template or an outlier. But for now, her actions have demonstrated something many Americans had begun to doubt. The system can move quickly when judges choose to make it move. And then the defense made it even worse. Within hours of the arrest warrants becoming public, attorneys for one of the named individuals released a statement calling the judicial action a grotesque abuse of power driven by illegally obtained evidence. Instead of addressing the contents of the tape, the specific allegations of witness tampering, evidence destruction, and family intimidation, the response focused entirely on the leak itself. This court has abandoned any pretense of impartiality, the statement read. Our client will fight these politically motivated charges with every legal resource available. Social media accounts associated with the defense began amplifying a new narrative. The tape was fabricated, the witness was coerced, and Judge Caldwell had been compromised by prosecutors. The problem with that response is that it addresses none of the documented facts. Legal communications expert Professor Kathleen Hall Jamieson pointed out the obvious flaw. When your defense is attacking the messenger while ignoring the message, you've conceded the message is true. They're not saying the witness lied. They're not providing alibis for the dates mentioned. They're not explaining the payments documented. They're just screaming about how the evidence became public. The response also created new legal exposure. By publicly attacking Judge Caldwell's impartiality, the defense may have handed prosecutors additional ammunition. Statements suggesting judicial bias can be cited as evidence of consciousness of guilt. Defendants who know they're guilty often attack the system rather than address evidence. Meanwhile, the other named individuals have remained silent. Their attorneys have declined to comment, issued no statements, and made no public appearances. Legal observers note that this silence may indicate active plea negotiations or simply recognition that speaking publicly can only make things worse. Perhaps most damaging, not a single voice has emerged to contradict Witness 14's specific claims. No one has denied the meetings occurred. No one has denied the payments. No one has explained why photographs of a witness's children's school would appear on their phone. When your response to 47 minutes of documented criminal conduct is, the tape shouldn't have leaked, you've already lost the argument. The court of public opinion has reached its verdict, and the legal courts are now moving to reach theirs. But beyond the immediate legal fallout, this is really about something much bigger. This is about whether powerful people can corrupt the justice system and escape accountability. It's about whether witnesses who risk everything to tell the truth will be protected or abandoned to face threats against their families alone. Witness 14 didn't leak that tape. They trusted the system. They entered protection. They told the truth under oath. And someone with access to sealed court records, betrayed that trust. But the betrayal exposed something the system had failed to stop. Months of obstruction, coordinated witness tampering, threats against children. If this goes unanswered, it signals that testimony is worthless, that witnesses who cooperate will be hunted, that evidence can be destroyed with impunity as long as you have enough resources and enough ruthlessness. Judge Caldwell's response represents a different choice. It says the system will fight back. It says obstruction will be met with immediate consequence. It says witnesses who come forward will be protected, not just by marshals, but by the full coercive power of federal courts. This affects every American who might someday need the justice system to work. And finally, it appears to be working. Here's where things stand right now. As of this recording, U.S. Marshals have confirmed that 2 of the 4 individuals named in the warrants are in custody. A third was apprehended at a private airfield approximately 90 miles from the nearest international border, traveling with 3 suitcases and over $40,000 in cash. The 4th individual remains at large. Marshals have issued a public advisory indicating they may have fled the jurisdiction. Federal agents are now coordinating with international law enforcement. According to sources close to the courthouse, Judge Caldwell has scheduled an initial appearance hearing for tomorrow morning at 9 a.m. The 2 individuals already in custody will be arraigned. Bail arguments will be heard, and prosecutors will present their case for continued detention. Legal observers expect prosecutors to argue for detention without bail, citing the explicit evidence of witness intimidation and the apparent flight attempt by the 3rd defendant. Meanwhile, witness 14 has reportedly been moved to a new secure location. Sources indicate their protective detail has been doubled, and communication with anyone outside the protection program has been suspended entirely. The tape itself remains widely available despite platform removal attempts. Legal experts note that its distribution cannot be contained, meaning every potential juror in the country has likely been exposed to its contents. Defense attorneys will almost certainly argue for venue changes, though given national coverage, finding an untainted jury pool may prove impossible. Keep a close eye on tomorrow's hearing. Bail decisions will signal how seriously the court views the flight risk, and any plea negotiations, if they begin, could break open even more explosive revelations. The next 48 hours will be decisive. The system is finally moving. Now we see how far. The stakes have never been clearer. The evidence has never been more damning. A federal judge has watched 47 minutes of documented obstruction and responded with immediate arrest warrants. Marshals are executing those warrants right now. What happens next will determine whether this represents a turning point, a moment when the justice system proved it could still function, or just another case that slowly drowns in procedural delays. This isn't just another scandal. This is the system being tested. And so far, Judge Caldwell is passing that test. Subscribe for continued coverage. Tomorrow's hearing could change everything, and I'll be here covering every development as this case moves toward its climax.